Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
No, sir. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are.
Hold on, this is already getting serious fast. The court isn't deciding guilt here. The judge is making sure Buckner understands exactly what he's accused of and the massive penalties attached to it. Witness intimidation involving threats of death or injury can carry up to 15 years, and the judge is carefully building the record before anything else happens. But Buckner is clearly emotional and struggling to process the moment. Do you think the court should slow everything down here, or is the judge handling this exactly the right way?
You may want to mute that.
My freedom just snatched from me, and I was understanding this son where I came to nothing to talk to me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong video, but now you tell me your video. That's what I'm not understanding, because the whole basis of my freedom today was the judge Simpson viewing the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th in Judge Washington Court. Okay. Attention. I understand the attention. I just, from the time, I apologize ever since, I'm a little slow right now. So I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge that Ms. Johnson, Ms. Washington want to find out. Yeah, I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case. As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. And then I need to be heard on it, and I can find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that the 22nd is not.
All right. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. So on the other matter, I'll set preliminary examination, and I hear what the defendant is saying. What date? April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
The allegation here is that my client allegedly had some outbursts and witness given this witness examination. I had a chance to look at what was available on the equipment that was done. They will be able to how all that stuff.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is first this Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and the assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at district court at exam. Condition of the bond in that case number 5-121. I'm sorry, I may have misread that case number, was that he had no contact with the victim. And here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case that he have no contact with the victim in Hudson, have a no coaching order as for residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is greatly concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and the state.
So in response, Your Honor,
Yes, sir.
obviously very clearly means something different to the prosecution than they describe it as an angry outburst. It doesn't rise to any attempt to keep anyone from anything except that angry outburst. They went ahead and tried to charge or witness intimidation. This is something based on what they saw in context and unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. Making a bond with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have had an angry outburst. That's a bond violation. That's exactly that context.
What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said, and that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate, should it be. That type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
Judge Washington, it's probably the same stuff that they charge me for right now. The same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at me and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington couldn't help me on this because they got me charged on. They got me charged, Judge. And so this thing, right? For me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, the community of people that was helping me, sir, and I know everything I'm saying, but you already made a decision, is that the video inside Judge Washington's courtroom, Wayne Washington courtroom, was the video that would prove my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, no, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention. This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr.